Welcome to this clip on EU state aid law and services of general economic interest, or SGEIs. After watching this video, you should be able to explain the concept of SGEI and discuss the basic principles regarding the compensation for an SGEI. We first turn to the relevant legal basis, which is Article 106 of the Treaty on the Functioning of the European Union, which reads in its first paragraph as follows. In the case of public undertakings and undertakings to which Member States grant special or exclusive rights, Member States shall neither enact nor maintain in force any measure contrary to the rules contained in the treaties. However, Article 106, paragraph 2 TFEU clarifies that undertakings entrusted with the operation of a service of general economic interest shall be subject to the rules contained in the treaties insofar as the application of such rules does not obstruct the performance, in law or in fact, of the particular tasks assigned to them. So, it is clear that Member States must consider EU state aid rules when compensating an undertaking for providing an SGEI. This is not surprising, as the concept of state aid within the meaning of Article 107.1 TFEU is an objective legal concept and does not depend on special political or economic objectives. It is important to first establish what constitutes an SGEI. There is no exhaustive list of SGEIs. Member States are free to define what they consider an SGEI. However, it is clear that it concerns services of an economic nature that have special characteristics and are important in the everyday life of citizens. Moreover, they are not sufficiently or at the desired conditions supplied by the market mechanism. Again, compensating undertakings to provide these services falls under the EU state aid rules, even though they are special political or economic objectives to SGEIs. If the compensation qualifies as state aid within the meaning of Article 107.1 TFEU, it has to be notified to the European Commission. That decides on compatibility with the internal market. It can do so on the basis of Article 106.2 TFEU and the SGEI package, containing an exemption as well as a de minimis regulation, or under Article 107, paragraphs 2 or 3. If a compensation meets all cumulative Altmark criteria, the compensation does not confer an advantage and is hence not considered state aid. The criteria entail that the recipient undertaking must be entrusted with providing an SGEI that is clearly defined. The parameters for the compensation have been established beforehand in an objective and transparent manner. The compensation does not exceed what is necessary, and where the undertaking which is to be entrusted with providing the SGEI is not chosen pursuant to a public procurement procedure, the level of compensation needed must be determined on the basis of an analysis of the costs which a typical undertaking would have incurred in discharging those obligations. While the criteria might at first sound straightforward, it is however very rare for a measure to meet the Altmark standards. In summary, an SGEI is a service of economic nature that public authorities find of particular importance to the everyday life of citizens, and which is not provided by market forces alone to the extent or under the desired conditions. Member States must consider EU state aid rules when compensating an undertaking for providing an SGEI, even though it has special political or economic objectives. This brings us to the end of the clip on EU state aid law and SGEIs. Thank you for your interest and attention.